We would be doing the editing on the back end in 1 minute, and they will be sharing with the audience.
Okay, perfect.
Thank you. Thank you so much.
It's on now. Good evening, everyone. Thank you for having me here. I would be starting with a brief introduction of myself. I graduated from LUMS Law School in 2021. After that, I started working in corporate and commercial law firms. So, my experience niche is primarily in mergers and acquisitions, joint ventures, regulatory restructuring, and data privacy. Currently, I am working with a Chinese enterprise that has a office in Riyadh, and I deal with the multinational clients for corporate transactional advisory work and the data transactions as well. So, the topic here today is cross border data transfer and what relevant privacy laws are being attracted there under. If I have to define cross border data transfer, I would say it's a transfer of information or data or the movement of data from one jurisdiction to another that makes it accessible to the people that are in another jurisdiction or sitting outside that jurisdiction. I would try to explain it with the airport example. For example, if you have to move out of Pakistan and you're at airport, you need to clear the immigration and the customs. So once they are being cleared, you are able to move out. Similarly, data is like that. If data wants to move from one country to another, it needs to clear the customs, and customs are the laws. Why does it matter, and why is it so important to be super careful when it comes to protecting your data or transferring it from one country to another? I would try to summarize it under three domains. The first reason is sovereignty. States are sovereign in itself. So data is power, and no sovereign wants to leave its power or give away its power. So when data is leaving one country or one sovereign, it needs to be under certain considerations. So that is why states like to control this data. Second would be the compliance costs. For example, if I have to comply with certain regulatory frameworks that come under one country, and once the data is moving out, it needs to follow that regulatory framework. And if there are violations, then there are huge penalties. The recent example would be Meta violation, when they had to pay $1.3 billion for GDPR violations. We would also be discussing what GDPR is and what are their violations in this session. Now, the important thing is not all data is same. So you cannot treat every sort of information in the similar way. So if I have to divide or categorize my data into the types which law has formalized, there would be two broad categories. For example, the personal data and sensitive data. Any information that helps to identify a person, for example, names, emails, phone numbers, or the information you put up in when you are signing up for Netflix, it is identified as personal data. And sensitive data would be hovering around health, biometrics, political and religious beliefs. I would say financial data, for example, salaries, credit cards, bank account numbers, they also come in the sensitive data. And if that data is leaked, it can cause serious harms. Imagine your medical history is being released on internet and everyone is able to see that. That's frightening, right? If you have to look at the metadata or behavioral data, we might think when we are scrolling or browsing some histories or browsing data, that is very random and harmless. But that's not the case. If you have this accumulated data in some accredited domain, you would be frightened to see that digital portrait of who you are. So, if I have to summarize the definitions for you, I would say data is the new oil, but if it is not handled with scrutiny and compliance, it can become a liability instead of an asset. And for future lawyers, whenever you are dealing with cross border data transfers, there are three questions that you must consider. First, where is that data coming from and where is it going? What type of data is it? And third, what approvals would be needed for that data to flow out? Let's pause here for some time and look at some major privacy regimes when it comes to data protection. So I have tried to summarize it like in 4 or 5 jurisdictions. The first one is European GDPR. It's gold standard. I would say it's a comprehensive one rule book जो पूरे यूरोप में available होगी. Every country in that jurisdiction would be able to follow that. It also gives very broad rights to individuals. For example, you must have heard about the very famous right to erasure or the right to be forgotten that is being granted in GDPR now, and initially it was in Europe. So, if you have to think of European GDPR as an example, I would try to draw an analogy. It's a strict visa officer. and you are going there to get the Shenzhen visa. But you cannot get the visa unless you have all the paperwork completed or all the compliance documents are properly fulfilled. So GDPR, that is what European GDPR do for the data when it comes to the transfer. और अगर यही डेटा आपको आउटसाइड यूरोप ट्रांसफर करना है तो यू नीड स्टैंडर्ड कॉन्ट्रेक्चुअल क्लॉजेस इट्स प्रिलिमिनरली सेफ गार्ड बुक अगर यूरोप से मेरा डेटा बाहर जा रहा है सो आई नीड टू कंफर्म कि सेफ गार्ड्स आर देयर और मेरा डेटा प्रोटेक्टेड है दिस इज व्हाट वी कॉल स्टैंडर्ड कॉन्ट्रेक्चुअल क्लॉजेस and most of the times they are available in the form of templates which we usually can follow. If we look at US, it's very much different. There is no single federal law. Instead, you have this patchwork approach. So there are different states, and every state comes with different laws. And that is mostly based on sectors. For example, HIPAA, if you have to look at their health, then you need to follow HIPAA, GLBA for banking, CCPA in California for consumers, enforcement wise they might not be very strong but that's how it works for them so aap samajh sakte hain that you are going to a country where there are different checkposts and every checkpost would be giving you something very different which you need to comply with that is how you can understand US laws. For Saudi Arabia, they have this very new PDPL that's very strict when it comes to implication and enforcement. Saudi law, I would say, if you have to define it, their focus is Saudi data belongs to Saudi. And if it needs to be transferred outside the kingdom, it needs to get the regulatory approvals. So it's very much sovereignty driven. It's very much I was saying that it was very much sovereignty driven. So the data stays home unless you have the government clearance. I hope so. It's you are able to understand it. For Chinese PIPL, China, they have PIPL, that is the strictest of all the data regulatory authorities. For them, the consent is central, but the data driver is national security. So आप इस एग्जाम्पल को इस तरह समझ सकते हैं if a person wants to move out of China, that person is data, it needs to have government clearance and it also needs to complete this paperwork. Our state is very much playing the main pivotal role in that. So the state security comes first. In सब examples में अगर आप देखें तो goal is primarily the same, that is the protection of privacy. But they have very different philosophies. For example, GDPR, it says or it protects the individual rights. US, it protects consumers, but it is very much inconsistent when it comes to enforcement. PDPL and PIPL. If I would say PDPL, it protects sovereignty, and PIPL, it protects the state control. And for the companies that are working across the borders, it's like they are playing with different playbooks. So it's our job as lawyers to figure that out and make it easy for them. Once you understand the gist और आपको एक preliminary framework समझ आ जाता है, it's very much easy for you to follow those inherent core principles and draft your contracts around that. So करंटली मैं एक ऐसे केस पर काम कर रही थी जहाँ पर मुझे अपना डेटा एक फाइनेंशियल इंस्टीट्यूशन से लेकर उसके हेड ऑफिस किसी और कंट्री में ट्रांसफर करना था. So to draft such contracts, there is not just one jurisdiction that would come under play. एक तो अभी I would be trying to break it down for you by giving a real example, and we would be taking this example, okay? We have this office of a financial institution in Riyadh, and that office needs to transfer its data outside the kingdom. We can say that it's in China. To understand this, I would be going over the basic definitions so you understand what certain term means, and then we can go with the transaction. इस तरह आपको रियल वर्ल्ड एग्जाम्पल भी मिल जाएगी और थीरी से बहुत डिफरेंट लाइक व्हाट यू आर स्टडिंग इन स्कूल it would be entirely different when it comes to the practice. So you would be having that gist or overview as well. So if I have to look at the relevant terms and definitions when it comes to cross-border data transfer, all of these laws which I mentioned previously, they have defined these basic terms by their own. And each term is similar. 1920 का आप डिफरेंस कह सकते हैं इस तरह आ जाएगा but by core they are same. So what does it mean when I say processing of data? Any operation that is carried out on that data by any means, whether manual or automated, that might include collecting, recording, saving, organizing, formatting, or any functional approach with that data, that would be processing of data. सो अगर सिंपल टर्म्स में बात की जाए मैं अपना डेटा एक कंट्री से दूसरे कंट्री में भेज रही हूँ सो दैट्स द प्रोसेसिंग and data subject would be that person to which that data is related. So agar mere customers hain, I have their information, I have their names, bank account numbers, their emails, their phone numbers, and I need to send that to my head office ताकि वो लोग अपने operational efficiencies और operational functions run कर सकें. So that I would be processing the data. My function is I'm trying to give you an example. मेरा function सिर्फ एक data को भेजना है. So that sending out data is processing. And then there are two different concepts of controller and processor. It does not mean if you are a subsidiary branch or a main branch. If you are sending out the data, you are controller. You would be setting out the rules. Under the jurisdiction, data is present. And if that data is processed and sent to the other jurisdiction, that other jurisdiction would be processor. So if I have to legally define it, processor would be any public entity, natural person, or private legal person that processes data for the benefit and on behalf of controller. If you look at the wording for the benefit and on behalf of controller, you might interpret it that controller does not have any will when it comes to processing that data. And that is very much right. If I am sending my data for a specific purpose, the data should be specified or processed just for that very purpose. I cannot make any changes. So our concepts for controller, processor, and processing are clear. So now we understand my Riyadh office is controller and China office is processor. How would data transfer work now? I do understand there are two different types of data. That is personal data or sensitive data. Once I have determined my data type, I need to understand what are the legal bases under which that data is being transferred to. What are the legal bases? These are the legal provisions or the basis by the word, it has its name. These would be, okay, I'm getting that comment, check your internet connection. Please let me know if you are able to hear me. Okay. So the legal basis would be the relevant legal provisions under which that data must be transferred. Okay, thank you for letting me know. I would be going through the legal basis now. Since my office is in KSA, the PDPL, that is the relevant regulatory law, it provides me 6 legal bases. Each legal basis has different implications and it would be attracting different regulatory provisions. For example, if my regulatory basis is consent, I have the consent of data subject, and I'm telling them very clearly that I need to process your personal data. So that would be one legal basis. The other would be actual interest. For example, I have to process my data on different servers, and that processing is beneficial for the data subject. But communicating with the data subject is impossible or difficult at the moment. but law does give me the permission to process that data in the very interest of the data subject. Third would be the contractual basis. If I have signed a contract with that financial institution as a data subject, then I can, or that financial institution can process my data. So that is a separate legal basis that is contractual. Fourth one would be the legal obligation. So every state has different laws, and if I have to process my data under that state, it would be the legal obligation. And if the controller is a public entity and the processing is required for scrutiny and judicial purposes, then I would be classifying it as public interest. And if the controller has some legitimate interest of the businesses, that is a very much, I would say, usual legal basis when it comes to transfer of data, that legitimate interest of the controller for its normal processing and functioning. I would be categorizing my data most of the times into this legal basis. But this legal basis also comes with certain implications. As I told you earlier, the data needs to be classified as personal or sensitive. So, sensitive data must come under different provisions and different implications, and there are strict rules for that. Once I have categorized my data, I have categorized the legal basis under which I am going to transfer my data, then our step three comes into play. But if I am choosing a certain legal basis, then I do need to mention the relevant provisions of that module or financial regulatory authority. I would say implications or the models which they have presented towards the public. After that, there are some principles for data processing, and these principles are very much similar in all the frameworks which I talked about previously. I would be going through some of the principles. The first one is lawfulness, fairness, and transparency. Lawfulness is the legal basis. I have determined my legal basis. I have figured out under what provisions I'm going to process my data. Then the data subject, controller, and processor, all three of them can have fair expectations when it comes to that transfer. And we should be transparent towards the data subject. So you can see that it gives very much rights to the data subjects or the public and us, for example, like how our data should be processed and what rights we are giving towards the institutions that are processing our data. An example would be the normal contracts or the terms of conditions. जब भी आप कोई ऐप पे साइन कर रहे होते हैं, कोई सर्विसेज ले रहे होते हैं, we might not usually read that, but this is what it primarily says. We are giving them the consent. The second principle is data minimization. The data should be minimized for the purposes which I have identified my data would be transferred to. I cannot add in other purposes. So I'm drafting my contract. I have figured out previously that my data falls into personal data and legitimate interest. And I cannot add in other categories of data or other purposes of data that are not documented. So it needs to be very clear what we are mentioning in our contracts or what we are identifying. I would try to define it like this stage, we usually say it's identification. You cannot maneuver it around, you need to strictly follow that. Third principle is purpose limitation. It talks about the very same thing. The purpose which I have identified, I cannot change that subsequently. Fourth one is storage limitation. So it might sound technical, but for us as lawyers, we did not look at the data in this way. We think that the information is there, but that information is entirely encrypted. And there are softwares that are going to protect and encrypt that information so that no other key can unlock it or no one can read that data. So if I am storing my data, the government, they are going to identify certain encryption standards or there are some rules in simple terms under which I can store my data for a certain period of time. And if I am going to store it for the time period that is not relevant or not mentioned, then it's a violation. So the data should be there for the minimized purpose, for the minimized storage. I cannot increase it by my wills. Fifth one is accuracy. So the type of that is why the audit or all these things come in when I have clearly defined and categorized things. Then the data being transferred, it is on the accurate grounds. And accountability, it's very much easy for the regulatory bodies to look at what sort of data is being transferred, and they can go over whenever they want. The seventh principle would be confidentiality. So I cannot disclose my data, and that is why most of the times privacy law comes in. If I have a certain party to which I can disclose data, I cannot add further parties, or I cannot remove or increase them as I think it's appropriate for me. The other inherent core, I would say, is data subject rights. So the law gives very broad right when it comes to data subjects. And I'll go through some very basic rights that are present in all of the frameworks which I mentioned previously. The first right is right to be informed. Data subjects have the right to be informed under the legal lawful basis and the purpose of their collection of the personal data. For example, they can send me a privacy notice, or they can send me an email, or when I'm signing those consent forms, they can let me know regarding that. The second one is right to access personal data. Data subjects have the right to access personal data which is processed by the controller. So मेरा रियाद का ऑफिस जो भी डेटा प्रोसेस कर रहा है, the customers data subjects, they can question it, they can access that data whenever they want. Third right is right to claim obtain personal data. If they can access the personal data, then they can also request the data to be provided to them in a very clear and readable format. Right to correct personal data. And this is also very wide. So, for example, I have given my bank some information. This is the place where I reside in. And after some time, I have changed my residence, or maybe there are certain different family members in my family that are being added or removed, or I want to change my information. So I have the very right to go to my controller and ask them to change it. And it is entirely their responsibility to update, to rectify, to delete whatever I say to them. Other right is right to request destruction of personal data. Similarly, अगर मेरा data outdated हो गया है, I can request them to delete it, or for the data request destruction. That is also very much common. I can also withdraw my consent. So I can tell them that I do not feel safe, or my company is under breach, or there would be some certain violations that are not in the favor when it comes to business of my company, and I can withdraw that information, and they are under obligation to remove that as soon as possible. Okay, these are the very basic rights. And if the controller, my bank, or any financial institution or any sort of institution to which I have signed my contract with, they are not listening to me, and I am seriously at the breach where my information is being leaked out, I can go to a competent authority always, and I can tell them that the law is not being implemented or the regulations must be followed, and they are going to carry a very heavy operation against that controller. So the law, it does protect us at the same time if we are going to study it properly. I would be going to the next section. So अब मैंने अपना कॉन्ट्रैक्ट ड्राफ्ट करना शुरू कर दिया. आई एम ट्राइंग टू एक्सप्लेन इट बाय द लॉयर्स परस्पेक्टिव नाउ. यूजुअली हमें काम मिला, वी started drafting the contract, I made certain sections and I figured out I cannot miss them. After the principles, legal basis, and after my data subject rights, I am going to go on the obligations of controller and processor. Again, controller is the Riyadh branch that is going to process my data for its operations. It has certain obligations. And what are those obligations? It is first, I should be aware of the as data subject of my data transfer. That processing of data, it should be under the processing agreement under which that processing is going to be continued. I cannot make any amendments whenever I want. The processor is okay, wait, let me open it clearly. Okay, so the controller, it is going to send specific instructions to the processor. So the Riyadh branch is going to send instructions to the head office in China or wherever they are, that these are the instructions, this is the data that needs to be processed, and no other ramifications or amendments can be made in it. This is what would be the job of me as a processor. I need to mention them very clearly. And these obligations should be under the organizational, administrative, and technical safeguards that are already promulgated by the law to protect the personal data. Everything is again very well documented. And if the processor is going to hire an other body or an other person, or if they are going to delegate whatever task I have assigned to them to another entity, then they are going to require my permission. And by my permission, I mean the permission from the PDPL, that is the law of KSA, because the processor, it first it would be regulated by the regulatory authority in KSA, and if they approve it, then they can add the sub processor. So again, it is a very strict implication. The processor cannot make any changes when it comes to even hiring a sub processor. Explicit consent should be obtained, and they should mention very clearly how and what person would be processing my data, where is it going to be stored, and what level of protections are going to be maintained. I have to verify if they have enough or sufficient compliance guarantees, and I have to notify the controller if there are any rights there that are going to be objected, or if there are any sorts of problems. So the PDPL, it has also made a timeline for the controller and the processor. अगर कुछ भी ऊपर नीचे हो जाता है, they need to be very clear, and within 72 hours or 48 hours, depending on the violation they need to, or the problem that they are going to face, they need to inform the controller, and they also need to inform the regulatory authorities. In KSA, usually the regulatory authority is SDA. That is also very much newer, but they again comes with a very strict enforcement. So if the controller is processing my data in a lawful and transparent manner, all the governance and compliance safeguards are being followed, then my data is going to be safe, or it's in the legitimate interest. This is primarily how does a normal data cross-border transfer work. And once we have included these basic principles, we need to add SSE templates. That is again the very much template I talked about when it comes to European GDPR. In Europe, if my data is going to be transferred outside the Europe, I need to have a certain template of the clauses. And those clauses should also be included in the jurisdictions or the countries that are not the parties of the PDPL. Once again, it's the golden handbook. It provides very much scrutiny. So you can include SSE template, and then your draft would be completed and it would be able to pass through the compliance checks when it comes to KSA. Once the data is leaving KSA under the encrypted models that have been identified and discussed, then the Chinese law would come into play. For China, if the data is inbound that is coming into their jurisdiction, they are flexible towards that. But when it comes to the data moving outside their jurisdiction, then again, different implications would be coming into play. For this, I would say I would be needing to run a last assessment check when the data has to enter into the Chinese jurisdiction. So if I need to clarify the protection elements or the assessment elements when it comes to auditing my contracts or the transfer of data, it would be data protection, it would be data enforcement, and it would be cross border after the data is being transferred assessments. All of these assessments, all of these records, we need to keep them in place so that regulatory authorities can access them whenever it's possible for them or whenever we are under scrutiny. Also, if I have to look at the penalties when it comes to Saudi law, 50,000, if I'm not wrong, is a very much high penalty when it comes to one single violation. So if it's not rightly categorized, if it's not rightly transferred, or encryption models are not there, I'm going to pay this much amount for each violation. So this is something that is coming into play, and it's very much important for our data. And I'm sure you would be having a very different look when it comes to now your random browsers or the random data that is being processed out. In Pakistan, if I have to talk about this, there is no such legitimate, or I would say, law that is being in promulgation. They recently presented this one bill that was approved by the cabinet, but it was waiting for the approval. Currently, we are dealing all such matters under Prevention of Electronic Crimes Act 2016, but we are also looking towards SSE templates or the other regulatory models for which for example, US, Chinese, Saudis, to strengthen our contracts. This is very much about the data transfer. If you have any questions, you can let me know. और अगर आप मेरे जर्नी के बारे में howsoever, like because I have practiced in Pakistan for some time and then I moved to US for I also wanted to get to know how do things work there. So if you want to know anything regarding my experience, how does it work around different jurisdictions, I am very happy to help, or you can even reach out to me after the session. I would be looking forward to the questions you have for me in the comments. Okay. Someone is saying that balance should be struck between economic efficiency, cloud computing, global business models, and individual privacy protections in the cross border data ecosystems. Definitely, balance should be struck, but I do believe that the stricter the enforcement is for violations, the better consequences are going to be there. And in Pakistan, we are hoping to see this kind of framework and this kind of model and enforcement for our own better future. Okay, someone says, does cross border data transfer regulation conflict with the principle of cyber sovereignty promoted by states like China and Russia? This is what we come in as lawyers. We need to figure out, we need to filter out all these compliance checks. And that is why we are categorizing our data in the initial place. Each category is going to bring different compliance checks. And the way you said, the principle of cyber sovereignty promoted by, yeah. So all of these states, these checks, first we take them off, then we are able to do that. Okay. Please do share the extremely grateful for such an insights. Please do share the documents. And is there any practical implementation session can happen in future as well? Definitely, I would be sharing the documents. Or if you would like to go through the overview of this summary, I can also attach my notes or the templates in the comments or after the session. I think there are no other such questions. Okay, so someone is saying, can multinational companies reconcile conflicting obligations under the GDPR, US surveillance laws, and local data protection regulations? So by reconciling conflicting obligations, mean you need the data transfer compliance checks. I'm not sure what you're trying to say, but if my multinational company has its office in a certain jurisdiction, then the relevant laws of that jurisdiction would be attracted. And if the processor is in another jurisdiction, then we need to check compliance for that jurisdiction as well. So it's like two double checks. Uh, okay, what is this? What repercussions do hackers face? Okay, that's nice. I think I would be begging a farewell now since everyone has put up their questions in the comments. Feel free to reach out to me. It was lovely talking to you, and thank you for having me here.